the scope of para 7 of schedule 2, para 7 of schedule 2, which says that supply of goods, the following shall be treated as supply of goods, namely supply of goods by any unincorporated association or body of person to a member thereof for cash, deferred payment or other valuable consideration. This is treated as a service. So this has got more than 50-60 years of history. So as I started saying, after independence, all our governments wanted to levy more and more taxes to generate more and more revenue. So everywhere possible, they were levying taxes. So at the time, the most important tax was only the sales tax. We did not have any service tax. Excise duty was there, but still sales tax was holding the field. The power to levy sales tax was on the state government. And as you know, the taxing power is divided between the union government and the state government. So what the state government did, they tried to do a lot of things. Construction of building. They saw that there is an element of sale involved. You are selling the cement, steel and all in the form of building. So I will put sales tax on construction activities. So they did. It went up to Supreme Court. Supreme Court said, when cement and steel is converted into a building and given as an immovable property, it is not sale of goods. You cannot levy sales tax. Then they wanted to levy sales tax on hotels. When you go and eat some food in a hotel, they wanted to levy sales tax on that. The matter went up to Supreme Court. Northern caterers, they said, the Supreme Court said, when you are going and eating some food in a hotel, there is no sale involved. It is purely a service. At the time, there is no service tax. It is purely a service. So they cannot levy sales tax on hotel activities. Then people also started a lot of ways to evade the taxes. See, if I sell my laptop, I have to pay VAT. So instead, what I can do, you want my laptop, you are ready to buy the laptop, but you are not ready to bear the tax burden. What I will say, I will give the laptop, you use it. Every month you give me the rent. The title will remain with me. I will give you the right to use. You will have the possession, you will have the control, everything, but the title will not be transferred. So it is as good as a sale. So government wanted to levy sales tax on that. And Supreme Court has said, there is no sale. Sale means there should be a transfer of title. Once there is no transfer of title, there is no sale involved. So you cannot levy sales tax. Another activity, there is a club. Like let us take, for example, Cosmopolitan Club or Madras Race Club or something, where the members go, they consume the food, they consume alcohol and other things, and they pay for it. Whether there is a sale involved, the government wanted to levy the taxes. They wanted to levy sales tax on sale of food and other items given in a club. Then it was argued, the matter went up to Supreme Court. One of the important case was this YWCA, Young Men's Christian Association case. There is something called Doctrine of Mutuality. I will come back to that little later. So my point is, wherever the government was trying to levy sales tax, that attempt was stopped by the Supreme Court in so many occasions. So the issues were referred to the Law Commission. The Law Commission has studied all the judgments and they suggested we have to make certain amendments in the Constitution. So unless we make certain amendments in the Constitution to bring more clarity on this aspect, you cannot levy sales tax. So the concept of deemed sale was introduced. So what they did, right to use, when possession and control is transferred, it is deemed as a sale. Hotel, it is deemed as a sale. Works contract, there is an element of sale involved in it. So whatever the judgments said where you cannot levy sales tax, everything was sought to be nullified by bringing one article called 366(29)A under the Constitution. And from then onwards, they started levying sales tax on that particular aspect. All these things happened between 1970s, 80s and all. This constitutional amendment was somewhere in 1982 or 86. That particular 42nd amendment was done. Even after that, the problem was not over. Now we will concentrate more on our present issue. We will not go to works contract. We will not go to other things at all. So what has happened? They brought one particular entry. Maybe I will share the screen.
Yes, I've enabled it, sir.
Yeah. Just a minute. So what has happened? This 366(29)A was introduced to levy sales tax on various activities. One of that particular activity is, just a minute. Yes. You are able to see 366.29a. There are A, B, C, D, E, F, 6 entries. You come to E, a tax on the supply of goods by any unincorporated association or body of persons to a member thereof for cash, deferred payment, or other valuable consideration. This is the definition of tax on sale or purchase of goods. That is the definition. It covers a tax on the supply of goods by any unincorporated association or body of persons to a member thereof. And then come to the end. Such a transfer, delivery, or supply of any goods shall be deemed to be sale of those goods by the person making the transfer, delivery, or supply, and a purchase of those goods. So they are deeming a particular sale. Say what has happened? The doctrine of mutuality means, see, for example, I am becoming a member of a cosmopolitan club. So the club is existing only for the benefit of the members. A non-member cannot come and buy any goods there. So all the members, they join together, they form the club for their own benefit. So when the club purchases various items, the club is acting as an agent and purchasing it on behalf of the members and then giving it to the members. There is no one person to other person. It is a collective transaction. In other words, a club is not different from its members. A club and a member are not two different persons. They are one and the same. All these members are operating collectively through the club. So club is the individual person and the individual person is the club. I cannot sell goods from my right hand to my left hand. So sale cannot happen. That was the earlier view. To overcome that, this particular entry was introduced. The government, as we know, many times they commit a lot of mistakes. That point of time, when this constitutional amendment was made, the problematic judgment for the government was that YMCA, Young Men's Christian Association. So what has happened in Young Men's Christian Association, 3 parties were involved. One is Young Men's Christian Association, another one, I think, Cosmopolitan Club, and one more is some Ooty-based club. All these are either a cooperative society or a trust or a company under section 25. So this company, cooperative society, they are all distinct entities. Under law, a company or a cooperative society or a trust is distinct from the members who are constituting it. Even in that context, the Supreme Court in YMCA said, the club may be a separate entity. They may have a separate PAN number. It may be a company under the Companies Act. It may be a cooperative society under the Cooperative Societies Act. Even then, there is a mutuality of interest. You cannot levy sales tax. That was the decision of 6-member bench of the Supreme Court in YMCA. But the Law Commission or the government, see, actually what the Law Commission said on this point, government referred the issue to Law Commission. Law Commission said for construction, we will amend, we will levy tax. For hotel, we will amend, we will levy the tax. But the club, we will leave it. They gave some reasons for it. One is, all these club transactions are very, very minimum. It is not leading to any big revenue involvement and all that. There is no evasion and all. If you put any tax on this, this cooperative movement will be affected. So club, we will not do any amendment. But for work contract, hotel and all, we will do the amendment. That is what the report of the Law Commission. But government overruled that. They wanted to tax the club activity also. So they have included class E also. If you see the statement of objects and reasons for the 42nd constitutional amendment, which introduced this article 366(29)A, there they say activities between incorporated clubs and its members are already taxable, but there is a problem in taxing the transaction between unincorporated club and its members. So we want to have a uniformity. So we are making this particular amendment. So the belief of the government was, if it is an incorporated club, like a company or a cooperative society, it is already taxable. If it is an unincorporated club, which means there will be no separate entity. Some 10 people will come together and we will form a club. We will not register it as a company or a society or whatever it is. It is just a body of persons. So there also we wanted to levy tax. So we are bringing this particular amendment. This is what the statement of objects and reasons said. After that, lot of changes have taken place. We will not go into all those things. And again, what has happened in 1994, service tax came. Initially, they started levying service tax only on certain services. And in 2005, one service was introduced, which is called Club Bar Association Service in 2005. In 2012, negative list came. So long this particular dispute was only in the context of levy of sales tax by the club. Now, the same issue has come to service also. People started arguing, I am a club, I am providing service only to my member. My members and the club are one and the same. There is a mutuality of interest. There is no service. I am not leviable to pay any service tax. This was the argument. That argument was accepted by various high courts. Ranchi High Court in one particular case, Gujarat High Court, and several high courts have said the mutuality principle will apply under service tax regime also. So the transactions between clubs and associations and the member, any service provided, you cannot levy service tax. So whatever efforts made by the government to amend the constitution and introduce Article 366(29)A E class subclass have been negatived by several other judgments. So all these things happened, lot of judgments have come, and finally the matter was referred to a 3-member larger bench of the Supreme Court. Because there were some conflicting opinions, it was referred to a 3-member judgment. This is one very, very important judgment, Calcutta Club. I request all of you to read it, not once, twice, maybe even 10 times also. It's whatever I have said so far, everything is there only from the judgment. So everything is there in the judgment, you have to read. So what the judgment said was, they said the first mistake committed by the government was believing incorporated clubs are already taxable. According to YMCA judgment, which was by 6 members, 6 judges of the Supreme Court, all the 3 parties involved were incorporated clubs. One was a company, one was a trust, and one was a cooperative society. In that context, the Supreme Court has said, even in incorporated clubs, even though the club is a different entity and the members are a different entity, the principle of mutuality of interest will apply. You cannot levy sales tax. This was the decision of the Supreme Court. But you wrongly believed incorporated clubs are already taxable and try to do something only for unincorporated clubs. So, as far as incorporated clubs are concerned, till today, the YMCA will apply. You cannot levy sales tax. You cannot levy service tax. GST also, we will come to that little later. So, this is one part of the decision of the Supreme Court in Calcutta Club case. Because of the mistaken belief taken by the government that incorporated clubs are already leviable to tax. That was a mistake pointed out by the Supreme Court in the Calcutta Club. So incorporated club has gone. You cannot levy sales tax. You cannot levy service tax. That is one part of it. Then unincorporated clubs are body of individuals which do not have any legal entity status. This was the intention of the government. They brought in clause E of 366(29)A only to tax the unincorporated bodies because they believed incorporated bodies are already leviable to tax. So regarding this particular aspect, what the Supreme Court has said, this is a deeming fiction. Mutuality of interest is a fundamental principle. If you have to overcome it, you have to overcome it very, very specifically. The deeming fiction should be very, very specific. But personally, if you ask me, I think this particular clause is sufficient. For example, if you see the last part of that clause, any such transfer, delivery or supply of any good shall be deemed to be a sale of those goods by the person making the transfer to the another person. But again, there the point is, once these two people are not different persons, that is the fundamental thing. What is doctrine of mutuality? Club and members are not different persons. They are one and the same. That has to be overcome. There has to be a deeming fiction treating the club and its members as a distinct person. Unless you do, this is also not sufficient to tax the transactions of what. This is what the decision of the Supreme Court recently in Calcutta Club. So, as far as incorporated clubs are concerned, Young Men Indian Association said it is not liable. You have not overcome it even today. As far as unincorporated bodies and body of individuals which do not have a separate legal entity status, even though you try to overcome it, that is not sufficient. You have not overcome it. So, you cannot levy sales tax on that particular activity. So, now we have to see what was the yes. Yes.
Now, after this insertion of E, levy of tax on goods is legal.
Levy of?
Tax on supply of goods is legal. What? Now, this E clause deals with supply of goods.
Okay.
F deals with supply of food as a part of service. There are two different clauses.
Yeah. F is to overcome the hotel transaction. That is valid.
Okay.
That is our previous entry, 6B.
Yeah, in most of the cases of club, F is also applicable. But that is not specified in E.
No, the doctrine of mutuality will come into play.
Exactly. My point is...
In fact, F was also argued. F was also argued, in the department argued, if not under E, my transaction can be justified under F. That was also one of the argument. But what the Supreme Court has said was, again they went back to statement of objects and reasons. They said F was incorporated only to overcome Northern Caterers. So only the keeping the hotels in mind, that clause has been created. So that cannot be applied for clubs. Clubs, there is a specific entry E, which does not meet the test, so it fails. So that argument was taken by the department. Okay, shall I proceed?
No, my one single point is this this amendment, constitutional amendment, insertion of clause E, was made to levy tax on goods. When the provision to tax on service tax on club transactions was introduced, was there any amendment, further amendment to that? No.
No, nothing.
Okay.
Nothing. Only they made some provisions in the statute. Instead of, they didn't do anything in the Constitution. In the Finance Act, they tried to overcome the doctrine of mutuality at different points of time in different manner. Okay. I'll just show that. See, pre-negative list. My screen sharing is there. Is it coming?
Yes, sir.
Has that Word file opened?
No, sir. Sir, you have to again
just share. Just 1 minute. Yeah. See here, this is pre-negative list. There was a service introduced by name Club or Association Service. Club or association means any person or body of persons providing services or facilities or advantages primarily to its members for a subscription or any other amount, but does not include any body established or constituted by or under any law for the time being in force. So actually, this particular exclusion was given by the government for some other purpose. Some clubs and associations might have been created by a special enactment. There they don't want to tax it. Not all the race club and cosmopolitan club and all. But this exclusion was interpreted by the Supreme Court in this Calcutta Club. They said, you have continued with the practice of not charging incorporated associations. You are excluding any body established or constituted by or under any law for the time being in force is not covered under the levy. I'm not saying. Supreme Court has said, once your club is a company, it is established under Companies Act. Once your club is in the form of a cooperative society, it is established or constituted under the Cooperative Societies Act. So your intention is to tax only unincorporated clubs and associations, and incorporated bodies specifically you do not want to tax. That is the legislative intention as interpreted by the Supreme Court, which may be right or may not be right, but Supreme Court is supreme. So what they said, incorporated clubs and incorporated associations will continue to remain outside the levy of service tax even after introduction of this particular service in the year 2005. So this will cover only unincorporated. For coming to unincorporated, whether it is permitted, whether 366(29)(a) E will apply, it will not apply. It talks only about goods. It doesn't say anything about the services. Doctrine of mutuality has to be overcome. You have not overcome. Service definition says service provided by one person to another person. When there is a doctrine of mutuality, two people are not involved. So once if it is an incorporated club, it is not at all covered under the levy. By way of definition, it is excluded. If it is an unincorporated association, you have not overcome the doctrine of mutuality. So service tax under club or association service, you cannot levy. on the both the clubs, incorporated, otherwise unincorporated, both. Then in 2006, government wanted to do something. What they did, they added this explanation. That explanation reads as, for the purpose of this section, taxable service includes any taxable service provided or to be provided by any unincorporated association or body of person to a member thereof for cash, etc., etc. So this also they try to overcome the doctrine of mutuality. One more thing. Before that, I will also tell one more thing. Whenever we read unincorporated association, there is also a body of persons. So government argued body of persons will cover the companies and all. So that also court has negatived. No, read your statement of objects and reasons. You believed that companies are already taxable. So body of persons, whatever is referred to here, will again refer only to unincorporated bodies and not incorporated bodies. So that argument was also negated. Again, this explanation, will it help? What it says, taxable service includes any taxable service. They are not overcoming the doctrine. They are not saying that the club and the person will be treated as a distinct person. If at all any taxable service is provided by a club to its members, that is also a taxable service. That will not help. Anything provided by the club to its members cannot be treated as a service at all, because there is only one person, mutuality. So this explanation introduced in 2006 also will not help the case of the department. So up to negative list, this is the position. Up to negative list, incorporated club or association, it is outside the levy by definition itself. Unincorporated, you have not overcome the doctrine of mutuality. So sales tax also cannot be levied. Service tax also cannot be levied. Then came the negative list. Negative list, there is a definition for the word person. Person includes an association of persons or body of individuals, whether incorporated or not. See, this is only definition of person. Person includes an association of person or body of individuals, whether incorporated or not. All will be treated as person. Okay. Then there was an explanation under the definition of service. 65B44, there was an explanation where it says an unincorporated association or a body of persons, as a case may be, and a member thereof shall be treated as distinct person. See, as per Supreme Court Calcutta Club, incorporated, unincorporated, there is no difference. The doctrine of mutuality will apply for both. That is the first point. The second point is, during the pre-negative list era, incorporated clubs are not at all covered under the definition at all. Unincorporated, you have not overcome the doctrine of mutuality. This is the position pre-negative list. Post-negative list, there is not much of detailed discussion on Calcutta Club. They have not specifically dealt with what will be the position of unincorporated clubs post-negative list. But what we can infer is, they are saying about incorporated. Even under this explanation is sufficient to overcome the doctrine of mutuality. In my view, this what it says, an unincorporated association or body of person, as the case may be, and a member thereof shall be treated as distinct person. If this explanation was not there, doctrine of mutuality will prevail. They will be single person. That has been overcome specifically in the manner laid down by the Supreme Court under the negative list era, again only for unincorporated. Because all along they believed incorporated entities are leviable to tax. They didn't want to do anything. But that was a mistake committed by the government. So what the Supreme Court has said, you are keeping incorporated bodies outside the tax net, even under the negative list regime. Because you are introducing the explanation only for unincorporated bodies. So impliedly, the Supreme Court has said, for unincorporated clubs, service tax will apply post-negative list. They have not said it so specifically, but if you read it very carefully, the conclusion is incorporated clubs are outside the taxable net even after service tax period and even after the negative list period. As far as the unincorporated clubs are concerned, doctrine of mutuality has been overcome by this particular explanation. So service tax may be leviable, maybe whatever I'm saying, it is, you can debate. We can debate and you can disagree, and we will revisit the opinion also. This is what my preliminary views on that. So based on this explanation, post negative list, unincorporated clubs, service tax may be payable by them. Then comes very important, GST.
At 1 minute.
Yes.
There is incorporated clubs or association. If it is a company, will the members be a shareholder or what will be the status?
No, that is also discussed here. See, if all shareholders are members, then the ratio will apply. If all shareholders are not members, or if all members are not shareholders, they call it as a proprietary club where this will not apply. It will apply only between the members and this one, and between non-members, it will always be taxable. Whatever mutuality we are talking about, it is only between the club and its members, whether it is incorporated or unincorporated. Fine? Okay. Now, moving to GST. See, we have to understand one thing. This Calcutta Club decision has come almost 1 year back. Almost 1 year back. Till that time, the government believed incorporated bodies, we have the power to levy the tax. No problem at all. So the problem will come only for the unincorporated bodies. This was the belief of the government. So whatever law they made, whether it is pre-negative list service tax or post-negative list service tax or GST law, everything was prepared keeping that particular notion in the mind. So but now Supreme Court has said, even for incorporated bodies, the doctrine of mutuality will apply. So we have to revisit everything because GST law was 2017, whereas the Supreme Court Calcutta Club is somewhere in 2019 or 18, somewhere. Now, coming to GST, Section 7, supply includes. We also had a lot of discussion on Section 7. All forms of supply of goods or services or both, such as sale, etc., 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 for consideration by a person in the course or in furtherance of business. One point which we have to note here is, it doesn't say by a person to another person. So the to another person is absent. We had a long discussion on this aspect also earlier. I will come back to that. The first requirement is the supply should be by a person. It should be in the course or furtherance of business. These are the two requirements. And it should be for a consideration. That is also important. So after long discussions, we have reached a conclusion, which we may even revisit today also. If you go to the definition of consideration, consideration should always flow from one person to another person. I myself cannot pay to myself. Right hand to left hand is not possible. So, by a conjoint reading of Section 7 along with the definition of consideration, we are taking a view that even though other person is not mentioned in the supply definition, still supply means two people are required. This was the view which we have taken earlier. If necessary, we will revisit also. So even though the need for second person, supply means supply of goods or services for a consideration by a person to another person absent. Even then, if it should be for a consideration. Once it is a consideration, as per the definition of consideration, consideration has to flow from another person. So even here, there should be minimum 2 persons to constitute supply. There are some exceptions. Under Schedule 1, they are making some distinct person transactions as a supply. That is an exception. We will come to that later. Otherwise, even under GST law, 2 persons are required to make an effective supply. That was the conclusion. Now, one more point which we have to note, definition of business. So, supply says the supply should be in the course or in furtherance of business. So, now what is business? There is a definition. We have spent almost a week to understand this particular definition. There, if you come to class E, incidentally, here also it is class E. Provision by a club, association, society, or any such body for a subscription or any other consideration of the facilities or benefits to its members. So, whenever any club or association or a society or any such body, here it doesn't talk about incorporated or unincorporated, it will cover everything. Whatever they do for their members is business. They are not saying it is supply. They are only saying that whatever the club does towards its members is business. So, it doesn't say the activity done by the club to its members will automatically become supply. So clubs are into business. Suppose let us say old bottles, liquor bottles are sold by the club, whether GST is payable or not. So we have to say the supply is in the course of business. The club may say, no, 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 I am doctrine of mutuality. I am not into business.
Audio only.
Audio only. I am. Is it okay now?
Audio only.
இல்ல சார்
Others are getting.
இல்ல எனக்கு தான் கேக்கலையா?
Yeah, yeah. உங்களுக்கு
மட்டும் தான் கேக்கல சார்.
The problem is only at your end. Is it audible now?
1 second.
Sir, it's audible, sir.
Yeah, yeah. For others, it is audible.
ஒரே ஒரு நிமிஷம். எல்லாரும் கேக்குதா?
இல்ல இப்ப நான் பேசல. இப்ப பேசட்டுமா? கேக்குதா?
கேக்குது.
எல்லாருக்கும் கேக்குது. ஜெயக்குமார் கேக்குதா? யாராவது சாட்ல கொஞ்சம் போடுங்க.
சார் உங்க வாய்ஸ் இஸ் கிளியர் சார்.
ஹலோ.
உங்க வாய்ஸ் கேக்குது. ஜேகே சார் வாய்ஸ் ஆல்சோ கேக்குது, பட் he is not able to listen.
அதான் அப்படியே சாட்ல போடுங்கங்கற. You just say it in the chat so that he can understand. Okay. Is it audible?
Yeah. Perfect.
Okay. So now, as per this class E of the definition of business, the activities or services provided by club to its members is a business. So the club is in business. Club is involved in business. They cannot get away by saying that I am not doing any business. It is a business. But it doesn't say the transaction between the club and the member will become a supply. That is not coming out from this. So this will help, as I said, maybe in cases like where old bottles, newspapers are sold by the club, they cannot say that it is not my business. They are still in business. It will be liable. So between the members, what will happen? For that, we have to go to again schedule 2. Schedule 2 says, that is where we are. Serial number 7 or para 7. Para 7 says, before coming to para 7, we have to understand this particular schedule 2 is created under section 7. What section 7(1)(a) says? First of all, a transaction should become a supply. A transaction, if it becomes a supply, then to decide whether it is supply of goods or supply of services, you can come to schedule 2 and decide whether it is supply of goods or supply of services. This is 1A. Prior to that, it was not like that. There was some confusion. There was an interpretation, even though a particular activity is not a supply, once it is mentioned in schedule 2, it will become either supply of goods or supply of services. That was not the intention. It was only a confusion created by the language of section 7, which they have corrected subsequently, but not retrospectively, I think. Now, any transaction which is mentioned in schedule 2, first of all, it should satisfy the definition of supply. Then, if there is any confusion to decide whether it is supply of goods or supply of services, then we can go to schedule 2. So keeping that in mind, if you read paragraph 7, once the doctrine of mutuality has not been overcome, once whether it is incorporated or unincorporated, the position seems to be the same, where the doctrine of mutuality is still applicable, there is no express provision under the GST law to overcome the doctrine. How it should have been overcome? Like the explanation under the negative list regime. A club and the member will be treated as distinct persons. That is absent even under the GST law. So schedule 2 will come into help only if you are able to prove the transaction. See, I'm going to a club. I'm having some food and other things. So the question will come whether it is supply of food or supply of services. To decide that, I can come to schedule 2. But before that, I have to satisfy the definition of supply. The definition of supply is not satisfied by relying only upon schedule 2. They cannot say all unincorporated club transactions and all will be leviable to GST. So that overcoming the doctrine of mutuality is still absent. One counter view could be under section 7, there is no requirement for another person. It talks only about to buy a person. So once there is a supply by the club either to its own members or whatever it is required, it will satisfy. So GST is leviable. This can be one counter argument. For that, our answer should be, even though section 7 does not mention anything about another person, by reading together the definition of consideration and other things, two persons are always important. Two persons are always important to make a supply. That is the implied interpretation. Still, the doctrine has not been overcome. Para 7 will not help you, because Para 7 can be applied only first you satisfy it as a supply. That itself is not possible because of this doctrine of mutuality. So that is how all these are consequences of one particular judgment. That is why I am telling you to read the judgment several times and try to understand so how the law has evolved over a period of time. So as I said, since Calcutta Club came later, the belief at the time of introduction of GST was that an incorporated club, there is no problem at all, and unincorporated, we can overcome. So another problem may come. Another problem, I said 1A was introduced somewhere in 2019. Till such time, the position was different. I will also show you how the previous provision was. Unamended section 7, how it read like that. Just a minute. Okay. 1 minute. I'm not ready. I was having the previous act also, GST. See, previous language. Can anybody take the previous version of, I was having it, but I'm not able to locate it immediately. So the problem will be, prior to introduction of subsection 1A, anything, even though a particular transaction is not a supply, by going to schedule 2, it can be presumed as a supply. That interpretation is possible if that view is taken from 1/7/2007 to 30th, whenever it was 1A was introduced. For unincorporated clubs, schedule 2 may help to levy the tax. But incorporated clubs are already away. As per the Supreme Court judgment, most of today's clubs are incorporated only. I don't think any of the clubs are still functioning as any unincorporated bodies. They are all only minimal. So incorporated, yeah, the activities to be treated, yeah, just a minute, I'll read that. Earlier it was the activities to be treated as supply of. So this will mean, even though a particular transaction is not a supply, once it is mentioned in schedule 2, it will become a supply. That was the meaning. That was not the intended meaning. Again, we may have to go back to the statement of objects and reasons for introducing 1A. That will help us, as it has helped in the Supreme Court case. So still, the department can argue, till the amendment, it will help. Even if it helps, it will help only for unincorporated bodies and not for incorporated bodies. And even that argument is also not a very strong argument. So I think, as I said, with the 5 o'clock, I was able to somehow cover.
This amendment was effective from 1/7/2017. Retrospective.
Oh, retrospective, no problem. Okay, and that is what the whole history behind the entire thing. Now I request all of you to read the judgment, and maybe we can continue tomorrow, I think. Yes, over to you.